Deemed prospectus. Now, as per Section 25 of the Companies Act 2013, it provides the provisions laid down for the deemed prospectus. Now, what is a deemed prospectus in general? In general, we talk about deemed prospectus as like what happens. Like a company, it agrees to allot some portion of its securities as open for sale to the public through an intermediary. So, any document by which this offer for sale to the public is made, any document, remember, any document through which this offer for sale to the public is facilitated is termed as deemed prospectus. Now, talking about the liabilities in case of misstatements in the prospectus or in case of omissions in the prospectus, then all those shall apply to it as if the securities had been offered to the public for subscription and as if the persons accepting the offer were subscriber to those securities. The offer for sale to the public, it is usually done in the following manner as it is given. The whole procedure for the issue of securities by offering it for sale to the common public. So in the company, instead of offering its securities to the public, instead of making a public offer to the public, what it can do, it can approach an intermediary called the issuing house. Now, what this issuing house does is that issuing house allots the securities for sale to the public by way of advertisement or circulation of its own. Now, this document is called a deemed prospectus because it's not the original prospectus, it is deemed to be a prospectus. Now, main reason for issuing an offer for sale through issuing house is that, now basically here we talk about the benefits. So the main reason for issuing an offer for sale through issuing house, it is that the company saves the underwriting expenses and in addition it obtains the expertise of the issuing house. So when an application is received by the issuing house, it renounces its interest in the securities to the extent of the number of securities allotted to the applicant, and in this case the applicant becomes the allottee of the company. The entire Companies Act and all liabilities in respect of misstatements applicable to the prospectus, it shall apply to this document as well. Now, in the absence of evidence to the contrary, an allotment or agreement to allot securities is deemed to have been made with the view to being offered for sale to the public. If the offer of sale is made within 6 months from the allotment or agreement to allot, ya fir at the date when the offer for sale is made, company has not received from the issuing house the whole of the consideration it is to receive for its securities. Now, the offer of sale, it must contain 3 certain things. Number 1, it should contain all the matters required to be stated in the prospectus under Section 26. This is all that happens in company law. It never tells you like what exactly do you need. It just